And I believe that that National Assembly can create a constituent assembly or a constitutional conference, not sovereign national conference. I did say not sovereign national conference. I'm saying constitutional conference or constituent assembly. To now look at the area, it is a body that can produce a new constitution if we want, with a provision about plebiscite. This can be done. I believe can be done. It's in my memo to the National Assembly. And I think I've sent a copy to Channel. All these things are argued out on it, that we can form this organization and go back. But that body will not include members of the National Assembly. You don't have to go amend the Constitution to empower you. It's not wrong. It's not right. Sorry. You don't go and use the authority as a National Assembly and then amend the Constitution in a manner that will empower you beyond every other person. I'll give you an example of what could happen. Now it is happening without a provision. It can happen with a provision tomorrow. The Arumote affair. Now I'm not holding brief for anybody. I don't know what our case is. But what I'm talking about is this: that a situation in which the House of Representatives passes a resolution saying that a particular official should be sacked. It is for the president to decide whether to sack that person or not. Whether I want the person sacked or not is not relevant. Now, if the president has said, I won't sack, with the greatest respect to my friends in the National Assembly, they have no power to go beyond that. This is my position. Now, to do things like withholding revenue and the rest of them to that body because the person they want sacked was not sacked, it's an element of legislative dictatorship. And that's what I'm afraid of when I see the word amendment and review.
All right, Mr. Hamba, unfortunately, we're out of time because we're even going to talk about your memorandum, which you called it proposed alteration. You didn't use the word amendment, having stated what the differences are now. But we're out of time on this one. But we will get you back so that we can look extensively at some of these matters and how they can also set up a constitutional assembly, as you say, because they keep giving different perspectives on this matter. But thank you for coming on, Mike Hamba, Senior Advocate of Nigeria, joining us from our Abuja studios. We're back after this. Please join us again.
Some say it's a sharp pain. Some might even say it's a shocking pain. And it's usually caused by hot, cold drinks. It definitely affects the quality of life. The treatment for tooth sensitivity can be very simple. Brushing with Sensodyne twice daily will give you long-lasting protection from tooth sensitivity. Sensodyne works inside the tooth and it soothes the nerve, and then the patient will have a relief of their pain. Sensodyne can be used every day. You don't have to use another toothpaste. For me to have a toothpaste that solves that problem so simply is what I like about Sensodyne.
Welcome back. Well, yeah, this is the other part of that fan boycott feud, which we started off with yesterday. Well, Tola Oshobi joins us this morning. He's the head of litigation by Boycott Services Limited. Morning, and thank you for coming on today.
Thank you very much. Good morning.
All right, then, give us a background to this, because we did see some part of it, hear some part of it yesterday, how FAN did raise a lot of allegations against Boycott, how they talked about certain infractions here and there. But one of the most recent ones also happened previously, I think over the weekend, about the hotel, the billboards, the right to put up those adverts and how it was removed. What went wrong?
Well, the issue of the adverts, or the removal of adverts by FAN, is just a continuation of the continuous refusal of FAN to comply with its contractual obligations with Boycott right from the commencement of the concession agreement granted to Boycott by FAN. At every stage, FAN has failed to honor its obligations to Boycott. Regarding the advertisements in particular, this is not a new occurrence. This happened, the first attempt by FAN to remove Boycott's advertisements took place, I believe, sometime in 2010 or 2009. And we, as usual, approached the courts. Because invariably, when you have an agreement between two parties, either at some point in the relationship, you have a dispute and both parties have a different interpretation of what the agreement says. At that point, the only option you have is either to go through the dispute resolution mechanisms stated in the agreement, or you go to court. In this particular instance, we went to court, and the court represented the issues to the court, and the court held or declared that Boycott had no right to remove our adverts. And if they had an issue with the adverts, that FAN had no right to remove our adverts. And if they had a problem with the advert, the appropriate thing was to go through the dispute resolution mechanisms set out in the agreement. And this judgment was delivered. FAN participated in the proceedings. They were represented by counsel. They never appealed against the judgment. They had the option to either appeal against the judgment or alternatively to follow the directive of the court and go through the dispute resolution mechanism stated in the agreement. They did neither of these things. This is the appropriate, legal, responsible, ethical, and moral thing to do, which they did not do. And
they claim that you ought to have been remitting some money to them from the adverts, and you haven't been remitting anything. Did your contract or your agreement say anything about remitting monies that you should have remitted?
That is absolutely incorrect. There's nothing in the contract that requires us to remit money to FAN regarding our adverts. Regarding the concession of, well, there are two issues here. We have the hotel, which is governed by separate agreement from the concession agreement for the airport. Now, regarding the concession agreement for the airport, yes, indeed, there is a concession fee, a general concession fee payable to the government. Now, this concession fee is not on advert revenues, it's on the global revenues derived, because the concession sets out various revenue streams from which Boycott is expected to derive income to recover its investment and to make a profit from the project. Now, there is no specific requirement to make remissions to FAN for advertisement. There's a general concession fee. But the truth is that as of today, FAN is owing Boycott a phenomenal amount of money, which is way, way, way above whatever claims. In fact, FAN has no basis to make any claims against Boycott today.
But FAN here says, and it's everywhere, that Boycott Services Limited owes them 19.6 billion naira for services it rendered to the operators of the MMA2 terminal since it started operations on September 8, 2007. And this is from Yakubu Dati's comments.
Okay, well, as I said earlier, when two parties go into a transaction, they usually document the transaction as a contract to bind them. A contract has been defined as private law made by individuals or persons or entities, more than two or more persons, to govern their relationships, which the court will enforce.